Thank you for speaking to us, Honorable Chief Justice. This is the first time that we're engaging with you on a one-on-one since the presidential petition. And of interest is the independence of the judiciary, which has come up as a talking point. There's a perceived improved relationship between the executive and the judiciary. Is it of concern to you that this perception might compromise what is seen as the independence of the judiciary in making decisions?
We cannot allow the independence of the judiciary to be compromised because it's a key principle in the Constitution that the way we operate, the way we make decisions, nobody can instruct us or interfere with our decision-making process. In other words, nobody can tell me or influence me in the way to determine the matter because they will be violating the Constitution. And I will be also violating the Constitution by listening to anybody telling me how to decide a matter, because it should never happen. So that's a solemn declaration we make. It's an oath of office we take. It's a commitment and a trust we carry for Kenyans to defend the Constitution. And I believe everybody, even in the executive and in the legislature, takes an oath to defend the Constitution. And one of the key principles is the independence of the judiciary. So if there is warm relationship between the judiciary and the executive, it is as it should be, because at the end of the day, Lilian, we are all serving one Kenyan, the one called Wanjiko.
So are you confident then, Honorable Chief Justice, that the executive will obey court orders and that in the event that there are remedial measures that they need to take where court orders have been defied, that they'll be able to seek advice on the same?
I think it is in the best interests of everybody to obey a court order. Because if you don't obey the court order, then it makes nonsense of the entire judiciary system that is there to protect and promote the rule of law. Even if an order is issued against you and you are aggrieved, you do not like it, you are supposed to obey it with utmost obedience, then challenge it or ask for a stay of execution of that order.
And how is it at a personal level between you, Honorable Chief Justice Martha Koome, and the President, William Ruto? You have previously said, when you were being interviewed for this position, that in cases where there were issues that needed to be resolved, that you would be the first to call the head of the executive at that time. Does the current environment allow for you to pick your phone and call the President?
Yes, it did, because when I have a problem, my training and all I do and all I have done is to resolve the problems. So if I know the problem that I am facing, it is only His Excellency the President who can solve it. Why wouldn't I pick up the phone and call his office and I say, I need to speak to His Excellency the President and have a meeting to discuss ABCD that requires his attention? Because we are in this together. If the judiciary fails, the executive will fail. We are just a three-legged stool that will have to stand when all the legs are up and standing.
And we're coming hot on the heels of the presidential petition. And in hindsight, there's been questions around some of the terms that were used during the petition, such as hot air, wild goose chase. Publicly, it would be presumed that some of this language was not as judicial as would have been expected.
Well, I don't want to comment on that case because I've heard that it is being processed further in another court in East Africa. So it could be what we call sub judice. But if you read the judgment and you followed the reasoning, there is a reasoning for each of those conclusions. Why the court made those remarks. Those are English terms. Perhaps they angered some people, but they were not meant to offend anybody. It was just an expression of the finding of the evidence that was presented before the court. Because, like, for instance, there were some forms which were brought from 34As, relying on the evidence which was hearsay. Nonetheless, the court went ahead to look at the original forms 34As to compare with those forms which were arranged to have been interfered with. And the court found that those forms were actually photoshops. The court went ahead to ask for the boxes, the ballot boxes, from all the polling stations where those allegations emanated from, where there was said to be interference. And Kenyans watched when scrutiny was done of those original forms in the boxes, comparing them with the original forms that were brought by IEBC. That exercise took no less than 36 hours. And that's why perhaps the court said, we did all this, but it turned out to be a wild goose chase.
Right.
So if you read the judgment, it will explain why each and every term was used.
One of the issues that your report highlights is the issue of human resource. And I suppose this means the inclusion of new judges and judicial officers into the judiciary. How has this helped fill existing gaps?
Human resource capacity for the judiciary is an ongoing process. Since I joined as the Chief Justice for the last 1.5 years, we've been trying to address the gap because the establishment is about 9,000 members of staff. That is judges, magistrates, judicial staff, including legal researchers, directorates, for the judiciary to be able to serve the 50 million people and to have courts in all the 290 constituencies and the 47 counties to have a high court. The establishment should be about 9,000. We've done well for the last 1 year because since I joined, it was about 55%. Now we have 66% of the establishment. We are still lagging behind in terms of the judges of the High Court. The establishment for the judges of the High Court is about 200. And we have in place only 62 now. This is because for the last about 8 years, we have not recruited for the High Court. We recently recruited for the Court of Appeal. So the Court of Appeal is having 29. The establishment is 30. The Supreme Court is full complement with 7. The EACC, Environment and Land Court, has 53 judges, and they are doing extremely well.
But despite the increased number of judicial officers and judges, the ordinary Kenyan still complains of their cases taking too long to be determined. And I'll give you an illustration of the Mwananchi feeling that whereas a presidential petition would take 14 days to be determined, we have corruption cases and murder cases that take almost up to more than 5 years to be determined. Will this ever change?
This is actually the vision of the judiciary that we have shared with Kenyans, that no case should stay in trial for more than 3 years, and no case should stay on appeal for more than a year. And this is a dream that can be achieved. Of course, Kenyans want instantaneous justice. And indeed, there is justification for that because nobody wants to keep coming to court year in, year out. We had a huge problem with the trial of murder cases and other criminal cases, especially corruption cases during the COVID period, because these are cases that required physical hearings. And it was a huge challenge for us to be able to mount a physical hearing when prisoners could not be brought from the prison. Some cases have so many witnesses and so many lawyers, like the ones you mentioned about corruption. You could have a case where there are 60 people who are charged in one case. Those 60 people, each one of them has an advocate or two. They also have witnesses. So it's like we needed like a mega tent to host a court like that, to maintain social distancing and conduct a trial during the COVID period. So, and also the reduced numbers of judges have led to this huge backlog of cases in criminal cases.
Honorable Chief Justice, when we look at the number of prosecutions and convictions around corruption, we find that they are fewer than of other cases. Does the judiciary intend to be more proactive in combating this vice of corruption?
Everybody speaks against corruption. We have all corruption. It's outrun in our constitution. It's a cancer in our society. But for the judiciary to be able to fight corruption, we need to work together with the other actors in the administration of justice. For instance, a judge or a magistrate dealing with a corruption case depends on the evidence that is brought to court. If there is poor investigations, if there is poor presentation of that evidence, if there is poor prosecution, it will affect the weight of this evidence that is brought to court, and therefore may not meet the test that is set in the law, that for a judge to convict on a criminal case, the case must be proved beyond reasonable doubt. You know, we also have our own reputation. Much as you feel that we are abhor corruption, the cases that are brought must be watertight to stand the tests of the evidence law that has been set, of the criminal law that guides us. So it is a collaborative effort, and that's why the vision of the judiciary, the social transformation through access to justice, addresses the issue of cooperative dialogue and working together, because we are like in a chain link.
But looking in-house, Honorable Chief Justice, how do you intend to address the issue of corruption within the judiciary for those that have been accused of being corrupt?
We have the Leadership and Integrity Act, Lillian. We have the Constitution that gives us the principles of leadership and integrity. Corruption is not only a crime, but it's an ethical conduct that is not acceptable. Within the judiciary, we have put mechanisms for reporting. And once the report is made, investigations are carried out. The Judicial Service Commission deals with these complaints. If there is an allegation of corruption against a judge, a judicial officer, or a judiciary staff, it is properly investigated. It is taken before the Judicial Service Commission. A hearing is conducted, a fair hearing, because you must give the opportunity also to the officer who allegations have been made against. And we are doing that quite often as the Judicial Service Commission. There are very many disciplinary matters there for hearing.
The appointment of the 6 judges of the Court of Appeal, who the former president had refused to appoint over integrity issues, does this close the discussion on integrity questions raised about these appointees? As
the matter stood, those appointees were nominated by the Judicial Service Commission. I have been at the Judicial Service Commission myself now for 1.5 years. I have never seen those allegations placed before Judicial Service Commission to deal with. Judicial Service Commission deals with all the problems that, all the challenges, all the disciplinary issues, all the complaints, and they come and they are recorded in a book. They are discussed, and according to the resolution of the Judicial Service Commission, they are sent to the officers for them to respond. And when we look at the response and the commission feels that this one needs to be interrogated further, requires a hearing, such hearings are held. And if they come up with further resolution that this requires the setting of the tribunal, then we make reference to the president. So the procedure is there of dealing with these complaints, but none has been brought before us.
Going back to the report, Honorable Chief Justice, the place of technology in improving access to justice. For instance, how many courts are virtual right now?
We have e-filing. You don't have to go to court to file. Very soon, we are partnering with the ICT Ministry to use the Huduma centers for the members of public. Instead of going to a cyber cafe, they can go to the Huduma center and find a desk for the judiciary where they can do their filing. So once you do e-filing, like Milimani, commercial courts, the civil division, the criminal division, I think Milimani is basically using technology in terms of the e-filing and also virtual hearing of some matters, except where they are complicated matters, where you need witnesses to come and testify, be cross-examined, produce many documents. But I can say almost 70% of the work at the Milimani is done through the use of technology. So is the Supreme Court, the Court of Appeal. We are completely almost paperless. And this is going on. It's an ongoing project where we are also piggy riding on the government technology reach to the last mile to make sure that every court is connected through the government fiber connectivity. And that way, you reduce the distance that people have to cover to come to court. People can conduct their matters from the comfort of their offices or even from their homes, especially mentions, applications. You don't have to travel to court for that. Delivery of judgments and the rulings, we do them online. And this is the way to go.
In terms of infrastructure, I want to zero in on the Sexual and Gender-Based Violence Court in Shanzu and what informed the decision to set up the court there, and indeed whether the magistrates that are handling these cases are trained to handle such sensitive issues.
It was data-driven. We had unprecedented number of cases of sexual and gender-based violence in Shanzu, that area. And it was felt that it is necessary to have a specialized court that can give full attention to these matters. In fact, there are 400 matters in Shanzu alone, that court. And survey is going on around the country so that we can set more. We hope to set, I think, 2 in Nairobi once we complete the survey. But it was all data-driven. The magistrates are fully trained, the staff are fully trained on the sensitivities of these matters, and especially the protection of the vulnerable witnesses, especially children who are victims of sexual and gender-based violence.
Yes. Finally, as the country's first female Chief Justice, Honorable Martha Koome, I'm sure you've had your fair share of highs and lows. So as we close, share with us some of your unique challenges while holding this position and how you've addressed them.
Of course, there has been challenges, many. There was the BBI dispute that brought a lot of tension in the country. So to be able to direct the country on the constitutional reform and the protection of our own constitution was also a major challenge that I think we were also able to overcome. Then, of course, came the electioneering period, which were very contested, bringing a lot of tension and anxiety to Kenyans. And the fact that we were also able to determine that dispute, and we had a peaceful transition where there was no bloodshed, there was no violence, there was no property destroyed, and the country has been able to transition peacefully, was also a big challenge that we have been able to overcome.
Many thanks for speaking to us, Honorable Chief Justice Martha Koome, and we wish you well.
Thank you very much for having me.